Good morning, everyone. It's a pleasure to be here. Thanks to the organizers for inviting me. I'm always hesitant to speak after Michael Moore because I fear there'll be nothing left to say. But I hope I will have something to say. I should say at the beginning that in the world of neurolaw, I'm the skunk at the picnic. There are people who believe, as I think the economists worried, that neuroscience, more than genetics, was going to transform our vision of ourselves, transform society, and do lots of very unpleasant things. The sorts of things that Michael Moore was just telling you, perhaps we don't need your help, and yet you can do your work very happily. I think I'm here to tell you that the economist was wrong, and that neuroscience, for all its astonishing advances and the astonishing advances to come, will not transform the law, will not transform society, at least not in our lifetime. If we do ever understand how the brain enables the mind, I think there will be a scientific transformation in our view of the world that is beyond my speculation at this point, but I don't think we're there yet. Okay. This is a case that has been the biggest intuition pump in the world of neurolaw. This is a case that was first published, many of you have probably seen this slide, in 2003 in the Archives of Neurology by Burns and an associate. This is a man who I've named Mr. Oft, as my neurologist colleague in Penn, Branch Coslett, said when he first saw this. You don't need to be a neuroscientist, a neurosurgeon, a neurologist, or anybody else to know that that stuff shouldn't be there. What that is a huge right orbital frontal tumor. It's a angiopericystoma. It's a malignant but non-metastatic, fast-growing tumor of the soft blood tissues. What happened in this particular case was a very normal guy, apparently a normal guy, got very interested in child pornography, started to develop interest in children, and molested his stepdaughter, was convicted. This tumor was discovered, taken out, and all of a sudden his desires for kids and pornography went away. Sent him into a program to fix people with sexual problems. He was just fine. He goes back home, and 8 months later, headache and interest in children are back, and angiopericystoma is back. It's resected again, and he's fine. So what's the intuition pump there? The intuition pump is his brain made him do it. And because his brain made him do it, it wasn't the act of an agent. He's therefore not responsible for himself. And this case has fueled the kind of epiphenomenal, if you will, challenge that Michael so ably presented. Now, the interesting thing is, we know from the time series in this case that without the tumor, he would not have had an interest in children or sexual desires for children. But notice, by the way, that that does not distinguish him from any other pedophile. No one, when they discover their sexuality somewhere in adolescence or young adulthood, looks at a list of possible objects of desire and says, I think I'll be a pedophile. You discover that you're a pedophile, and it's typically not your fault. Well, these urges were not his fault, but it's not a crime, it's not even immoral, in most people's theory, to have pedophilic desires or urges. It's a crime to act on them. And the question is whether he was responsible for acting on them. Okay, let me give you a bit of brief interdisciplinary history in the field. In 1991, an upper-middle-class New York executive strangled his wife to death after an argument and threw her out their 13th-story window. He was called Spider Siskoff in the literature. What happened was, it was discovered in a workup that he had a huge subarachnoid cyst. What you're seeing on the left-hand side is, for those of you who don't do this, a structural MRI. On the right-hand side, you see a PET scan, because this was before fMRI was discovered. And he was going to use this cyst, the existence of this cyst, to claim that he was not responsible for himself. He couldn't control himself as a result of this cyst. It was an entirely implausible claim, by the way, because it had an absolutely unexceptionable history before then and afterwards. But people said this was really the beginning of neurolaw. In the event, he pled guilty the night before trial to a lesser included charge of manslaughter rather than murder, and so we don't know what would have happened at trial if he had gone to trial, but this was allegedly the beginning. And the case was, in fact, published in 1992. His real name is Herbert Weinstein. He was called Spider Siskoff because subarachnoid cyst, Spider Siskoff. All right, in 1991, as most people in this room know, in a laboratory at Massachusetts General Hospital, fMRI was discovered. Starting in 2000, there were many, many magnets available in psychology departments and in neuroscience departments where you see good, non-clinical, basic behavioral neuroscience. And what I'm talking about is behavioral neuroscience, by which I mean cognitive, affective, and social. You see a logarithmic increase in the number of studies. And then 2003 was Mr. Oft, which was a much stronger intuition pump than Spider-Siskoff. And what this led to among the lawyers was basically brain overclaim syndrome. People got giddy and thought neuroscience is going to transform the law. And the reason is because neuroscience is going to undo the primary behavioral assumptions upon which law, as a system of social control, is based. Now, law and medicine are really important in the following sense. They affect people's lives, and law not only affects their lives, it affects their liberty, it affects their money. It is really crucial. So the question then, in thinking about legal arrangements, which has such an important effect on human beings, is what do we really know and what are its implications? That is the question. And my thesis is, and I've just given you a couple of my assumptions, I am a physicalist, a monist, I believe in multi-field, multi-level causation. I am, as Michael said, a compatibilist. And I think about the challenge of neuroscience to law, it's more hype than hope. And I identified in 2006 a very malignant psychological disorder, which I call brain overclaim syndrome. I've written about it further since. It's a hypothetical disorder, and I recommended cognitive neurotherapy as a very cheap, effective, and non-invasive treatment for this disorder. Now, if you're ever going to think about what is the relationship of anything else to law, I don't care if it's neuroscience, genetics, whatever it is, you have to have a basic sense of what law is. So I know this is breathtakingly superficial, but let me just say that law is a system of rules that are meant primarily to guide human behavior. That is the fundamental purpose of law. Law does other things as well, I believe, like create value. But its primary goal is to guide human behavior. Now, once you understand that, you understand immediately the kind of creature to which law is addressed. There are no dolphin legislatures. There are no avian police, etc., etc. Law is addressed to creatures like us. Now, what kinds of creatures can use rules as part of their practical reasoning to guide their behavior? Well, it's folk psychological creatures who are reason responsive. Because what does law do? It gives you reasons to behave one way or another. It doesn't mean you have to follow the rule, but it does give you a reason. Now, those reasons might be simply consequential. Those reasons might be because you understand the underlying purpose of a rule, but it gives you reasons. And once you understand that law is a thoroughly folk psychological enterprise, you understand what the criteria for responsibility are. They have basically to do with rationality. Who can adequately use those rules to guide their behavior? And the reason we excuse or mitigate very young children, some people with severe mental disorders, some people with dementias, and the like, is not because they're determined. It's because they lack rational capacity, either as a result of abnormality or as a result of developmental immaturity. Now, we can argue about how much rationality you have to have, of what sort, but that is the criterion for responsibility by and large. Okay. Now, once you understand that, come on, here we go. Once you understand that, then the question always is relevance. How precisely, and you could substitute in neuroscientific, you could substitute genetic, psychological, astrological, I don't care. How precisely do neuroscientific findings answer a folk psychological legal question? Now, what I mean by a folk psychological legal question is this. All legal criteria are acts and mental states. Free will is not a criterion for any law. In fact, free will isn't even foundational for law. Now, many of you may think, well, so much the worse for law. I'll have an answer for that in a minute. Not one necessarily that will convince you, but an answer. Now, once you understand that you've got to answer a folk psychological question, you have a very interesting point of translation. If you look at psychiatry and psychology, sometimes they treat people like a hunk of meat, but they also treat you as an acting human being. So if you're depressed, for example, and you go to your mental health professional, and all she does is offer you as a pill, she's treating you as a hunk of meat. And that's fine. It may in fact be a very effective treatment. But she should also be asking you about your life. How's your loving? How's your working? How are things going? And if your mental health professional just treats you as a piece of meat, then I think you need to find a different mental health professional. But what this means is, when trying to relate, let's say, psychology or psychiatry to law, you've got a natural affinity because, at least in part, psychiatry and psychology are folk psychological. Neuroscience is purely mechanistic. Neurons do not have reasons. Again, I'm begging the question against a certain form of reductionism, I know. But to the best of our knowledge, neurons don't have reasons. Even the connectome doesn't have a sense of past, present, and future. It doesn't have aspirations. These are qualities of acting human beings. As a result, actions speak louder than images, or actions speak louder than snips, actions speak louder than psychological tests for law. Because if there's a disjunct, cases of malingering aside, we always have to believe the action. So as many of you probably know, diffusion tensor imaging has shown that the adolescent brain is not fully developed at age 18, the age of majority, at least in American law. Well, suppose the diffusion tensor imaging hadn't shown that. Would anyone think that adolescents are indistinguishable from adults? No, because behaviorally we know and have known forever that kids are different in some fundamental ways. If someone is clearly not malingering and is indicating psychotic mental states, even if the brain looks fine, we know they're psychotic. On the other hand, if the brain is broken as could be, but they're acting totally rational, for legal purposes, they're rational agents. Okay, neuroscience is now these are the radical challenges for those who really want to say law is based on an illusion entirely. The first is determinism. Well, neuroscience can't prove the truth of determinism. No science can. Determinism, in its many forms, is a working hypothesis of scientists. It's something I certainly believe is quite close to true, if it's not actually true. But there are good answers, and Michael has suggested what they are: compatibilism, which, by the way, in a poll of philosophers some years ago, is vastly the dominant view among philosophers, not the only view. And this is not going to be resolved, but there is an answer in philosophy. And the interesting thing about law is we lawyers cannot wait for the doctors of metaphysics and the doctors of science to solve our problems. You know, when the Supreme Court ends a decision, it says, "It is so ordered." There has to be a decision. And we cannot wait till all the underlying problems are solved. And determinism is nothing new in neuroscience. There's been genetic determinism, there's been social structural determinism. This is an old story, and it's not going to get resolved. To me, the more interesting challenge is what I call the disappearing person, or the victims of neuronal circumstances after Green and Cohn, or pack of neurons after Francis Crick. We're nothing but neurons. Again, agency goes away. We're not really agents as we think we are. And people use limit as the primary neuroscience argument for that being true. Well, contrary argument. I don't have time to go into it now. I just quote some people, two of whom are in the room: Jerry Fodor, Al Mealy, Michael Moore, I think have shown convincingly on conceptual grounds why we have no reason to believe we are not agents. I think there's a ton of contrary evidence, some of which is simply anti-lipid, some of which is pro-we are agents. So Aaron Scherger, Utah, I hope I pronounced that correctly. And then common sense, which Tim O'Connor pointed to yesterday. I tell my law students, don't leave your common sense at the courthouse door. Thank you. There are tons of laboratory experiments that show that intentions are efficacious. If you think about evolution, this was something that was referred to yesterday, we know that sort of theory of mind, the appreciation of mental states as affecting action, is present in New World monkeys, which split off from us 40 million years ago. 34 million years before our closest relatives, the gorillas, chimps, and bonobos. So this has been conserved for 40 million years. Is it really likely it's purely epiphenomenal? It does nothing? This is not a slam dunk argument. It's an inference, and it's a strong one. Theory of mind. Think about people with autism spectrum disorder. They are very humanly, functionally disabled. Obviously, it's a continuum concept, but our ability to read each other's minds successfully is what makes human interaction successful possible. Is it really a plausible hypothesis that we're just a bunch of neurons interacting as we do? And I'm not suggesting, by the way, that the brain isn't crucial. It is. Your brain is dead, you're dead, you're not of much interest at all. All right, I just want to quickly go through some of the scientific problems. And again, I don't want any of the neuroscientists in the room to think I'm saying what you do is useless, you're no good. I think what neuroscientists do is astonishing. I've done it myself. Thou shalt not sit with statisticians nor commit a neuroscience. Just basically riffing off Auden. Here's the fundamental problem. And it's why, by the way, there are basically no new psychiatric drugs in the pipeline. We don't know how the brain enables the mind or how action is possible. We know the brain is necessary, but we don't know how yet. And there are people who think we'll never know how. It's too hard a problem, the so-called Mysterians. I'm not one of them. I think it's at least plausible that it's soluble, but we're nowhere close. Neuroscientists don't go on fishing expeditions. They've already identified some phenomenon of interest to them, impulsivity, addiction, schizophrenia, for example. They've already clearly behaviorally identified those with and those without, and now they look for neural differences between the two. But notice what's doing the work. Psychology is doing the work in the most cases. Many of the studies so far in behavioral neuroscience, I want to be clear, I'm talking about cognitive, affective, and social, small subject size and insufficient power. In a recent study appeared in PLOS 1 by Ioannidis and Zook of Cambridge, of Stanford and Cambridge, they suggested that on these grounds, probably 50% of cognitive neuroscience studies are probably wrong or not reproducible. You're averaging over the subjects. The question, of course, in an individual case is, can you draw an inference about an individual case from group data? And as many of you know, when you see in those wonderful images, this is the area that activated. It could be that none of the subjects activated in that area. It was just the average activation. Ecological validity, who are the subjects of most cognitive neuroscience? They're university students, hardly a random sample of the population, and barely a random sample at all of felons, maybe. Response biases and artifacts, you all know about that, research problems. There are almost no directly relevant neuroscience studies to law. Most of what we know, John Dylan Haynes notwithstanding, is correlational. It's coarse, it's not causal, and it's not fine-grained. Clear-cut problem means this. Remember what I said about neuroscientists don't go on fishing expeditions. You have clear case of schizophrenia, clear case of someone without. We didn't need the neuroscience to help us distinguish. What about the gray area cases in between where we might need help? Is this person really schizophrenic, or are they grandiose, for example? There, the data are going to be completely overlapping, and you're not going to be able to get the help when you need it most. Finally, countermeasures. That will be a problem if it ever gets used. Here's the major problem. We're talking about law. Law affects people's lives. Before I make a change in legal policy, in legal adjudication, I want to know I have a secure basis for doing it. We have a replication crisis not only in medicine, not only in psychology, we have a replication crisis in neuroscience. Again, it's a young science. People don't get research grants for doing what the other guy did, so it's not a surprise. All right, let me just finish up quickly. I have a cautious, optimistic story. I don't have time to tell it. That says basically neuroscience in the future may help us make modest improvements in efficiency and justice in the legal system. But for now, the contribution is going to be modest at most, and don't worry, be happy, we're agents. Thank you.